so much for watching this PEAR Core Solutions presentation, Hack HR in 3 weeks. Over these 3 weeks, we are going to cover some no small subjects. This week, of course, we are talking about sexual harassment in the workplace and being prepared for that. And we hope you'll tune in over the next couple of weeks for the other two in the series. Urgent HR changes that you need to know about is coming up next. And then we're going to talk about performance management that actually produces results. So again, thank you for watching. This is going to be short, but we hope that this is going to be a helpful overview of the current landscape of sexual harassment in the workplace. And we're hoping to help you to recognize it, to understand that it could happen at your company, and ultimately, of course, to prepare for it. So before we get into the details, just a quick word about who we are, PEAR Core Solutions. We are a human capital management firm. What does that mean? It means we provide HR support. We're going to provide more details at the end of this, but for the moment, I am David Friedman. I'm joined here by Stephanie Quinn, and the two of us are going to be walking you through this presentation. By the way, a quick word about what we do on a day-to-day basis is we provide HR support to our clients, which might include listening to complaints of all sorts and not just related to sexual harassment. So again, we're gonna provide some more details at the end of this about who we are. But for the moment, let's get into it. So the basics of sexual harassment, that really does sound basic and even obvious. Doesn't everybody know what sexual harassment really is? But it may not be so obvious. So let's talk about it.
So sexual harassment means harassing someone because of their sex or gender. So this could mean offensive remarks about a person's sex, and that includes jokes, unwelcome sexual advances or requests for sexual favors, or it could be verbal or physical harassment of a sexual nature. Now, this is different from sexual discrimination. Sexual discrimination is making employment decisions because of a person's sex or gender. This could mean hiring, firing, promotions, or layoffs. It could mean making decisions on pay, benefits, job assignments, or training based on their sex or gender, or the terms and conditions of employment. So by the way, on this and any of the other slides in the presentation, you can replace the word sex with, for instance, ethnicity or age, and we're still talking about the same issues that can arise and the same or similar laws that can apply. So let's talk about the laws. You may be in line with federal laws, but as you are no doubt aware, state and local laws can be much more complex and even contradictory. So the states above are just two examples, and they are deceptive. So the California Labor Code is a deep and complex set of statutes. And on the enforcement side, of course, you therefore have to worry about multiple enforcement agencies that could come knocking on your door. A disgruntled employee may go straight to a lawyer, but they may also go to the EEOC first, in which case you are going to be involved in a complex process with the EEOC, only to then find yourself potentially dealing with lawyers in a follow-up lawsuit.
So speaking of lawsuits, you can be on the right side of the law and still find yourself in a lawsuit, right? Let's talk about an example under sexual harassment. The EEOC may investigate a complaint of a hostile workplace environment, but then they may not find any evidence and they may drop the case, right? And you might think that that's the end of it. Similarly, for sexual discrimination, you may have equal pay for equal jobs at your company. Employees may be hired and promoted based on their merits, and maybe there are plenty of women in leadership positions. With both of these examples, you might be following the letter of the law, right? But an employee may still sue you, and no matter what, this is going to cost your company time, of course, money to litigate and to settle. Let's not forget to consider the press implications. This is very likely not to stay entirely quiet. Somebody is going to hear about this in the outside world. And still on the inside, you still have your existing workplace to contend with. There are going to be internal whisperings. There may be strife among your employees because of the lawsuit. And you want to try to avoid that as much as possible. So, in the end, it really doesn't matter if the employee wins or loses. You want to avoid the heat. You just don't even want to be here if you can avoid it. All right, let's talk about who is protected and who can offend. And the answer quickly is everyone. Every employee has a responsibility not to harass or discriminate against others. Your supervisors can't harass their direct reports, and your direct reports can't harass each other. And also every employee should be protected from harassment and discrimination. You're just as likely, and perhaps even more likely, to experience a claim of harassment or discrimination from a higher level employee as you might be from those lower levels. So you have to pay attention to the entire company and to everyone. And the company should proactively take responsibility for all of this. You got to have your ears to the ground. You have to know what's going on, and you should take action to both encourage proper behavior, proper in quotes, and to shut down improper behavior.
And let's not forget that your employees don't only interact with each other. Employees can harass customers or clients, whether in person or on the phone, and customers or clients can harass employees. And again, this doesn't have to be in person. And your company could be liable in either situation. Let's also keep in mind that it's simply bad business to harass or discriminate. Let's talk about LGBT employees. Employment practices that adversely affect LGBT employees will be handled the same way as actions that adversely affect women. Some examples for discrimination: if a company regularly doesn't promote a gay or transgender employee because of their sexual preference or gender identity, the EEOC will see this as equivalent, for example, to not promoting women because of their gender. And an example of harassment would be an environment that allows for regular jokes about homosexuality. And this will expose a company to the same liability as a company where jokes about women are prevalent.
All right, so you may think you have a perfectly happy workplace, so of course there are not going to be any harassment complaints, and you may also think that because it's never happened before, that it's never going to happen in the future. So let's get into this a little bit. Here at PEAR, we really have heard it all. From the industry to the absence of women in the workplace, to the fact that women are in positions of power. It's very easy to come up with excuses as to why a quote innocent joke is okay, right? And it's easy to take the fact that you haven't heard any complaints as a sign that everything must be fine. And it's easy to say that it's too hard to change the behavior of your employees, simply because that's the way it's always been, or that's the way it is in your industry. And, listen, we understand, it can feel unnatural and basically downright fruitless to tell a group of, let's say, garbage collectors that they're not allowed to make sexual comments, even if there are no women around to be offended.
So no jokes are allowed at work. Some examples are jokes that relate to gender, sex, body parts that relate to sex, gender identity, sex changes. You need to nip these in the bud, and not just once, but every time. Your supervisors have to be your gatekeepers on this, so obviously you need to get their buy-in. Also, it's not enough for them to say, because corporate told me to tell you this. They must be committed to upholding the policies and helping to uphold a workplace environment that is respectful to all. Let's talk a little bit about the Me Too and the Time's Up movements. It's not like any of what we're talking about here should be news to you, but there have been laws on the books for more than half a century, and women are doing every job that men do, include fighting in the military. So what's changed? We're not going to get into the deep and divisive political and social implications here. So suffice it to say, women are feeling more empowered than ever to avail themselves of the rights, both legal and ethical, that have been granted to them.
All right, so we want to get briefly into a case study. This is based on a real client of ours, of PEAR's, and what makes this a really good example of a case to get into is that it involves both sexual harassment and discriminatory treatment, and it was all kind of neatly wrapped up into one complaint. So let's get into a little bit. You know, if you have ever bought or leased a car, you know the process, right? You first deal with a salesperson on the floor to choose your car, you know, and then you likely sit in a windowless office with a finance person. You sign 1,000 pieces of paper while you're surreptitiously being sold additional services that you know, you may or may not need, such as an extended lease or car care program, right? So we're not going to get deep into the details here, so suffice it to say that one of the people involved in this sales process sued their dealership, and it was based on two main things. Number one, he sued the company and his coworkers. Yes, it can go for the coworkers too, for harassment, and this was based on the assumption that he was the focus of constant sexual oriented jokes, and because everyone thought he was gay. Of course, you know, this is what he was saying, is that everyone at the company thinks he was gay, so they harassed him. He also sued the company in addition for discriminatory treatment, and this is what Steph was talking about earlier, that taking some sort of actions that adversely affect an employee. And what he claimed was that he wasn't given enough opportunities to make money. And again, this was based on the fact that, as he said, everyone thought he was gay. So, you know, this took the dealership by surprise for a couple of reasons. Number one, he was in many ways the band leader of this behavior. He was right there with all of them, sometimes starting it in terms of the locker room talk and such. So nobody thought, of course, that he was offended. And also, he was a he. And you know, you don't usually expect that. You usually expect these things, these lawsuits, these complaints to come from women. So, but ultimately, you know, it should not have taken this company by surprise, if for no other reason that this was not their first suit. So, you know, so what happened next was, well, the lawyers, of course, they got involved, and the dealership contacted us, PEAR, to perform an official workplace investigation. And so, you know, suffice it to say that in the end, they had to spend a lot of money. You know, we won't get into any other the details on that, but you know, ultimately, let's talk about the fact that let's discuss, could this have been avoided? You know, and the answer is maybe not, but we do know this for sure. Number one, their policies that they had in place were aged. They were not well communicated. You know, there might have been employees that had seen the sexual harassment policy 10 or even 20 years ago. We have some very long standing employees here. And number two, you know, management really did not have their ears to the ground. They didn't know that any of this was happening, or let's say you don't believe that they didn't know. So let's assume that maybe they knew something, but they just figured, hey, you know, that's the industry, right? We saw that earlier, that it's the industry is frequently an excuse for why something happens.
Okay, so let's talk about what you can do now to make sure you're prepared to handle a claim, as well as hopefully avoid one entirely. We'll start with a written policy. There's not much to say here. You need the written policies, and you need to have them up to date. You also need to ensure that every employee has read them, and you have evidence to prove that they have read the policies. What do you do if someone puts forward a complaint? It's easy to think that everyone simply knows what to do when they have a complaint, but keep in mind that telling employees to talk to their manager if they have any issues is not always enough, particularly when so many instances of sexual harassment relate to managers and their direct reports. You should have a clearly communicated procedure for what to do if you have a complaint, and even consider multiple avenues possibly based on the nature of the complaint. Make it okay for people to complain, and make sure that they know they will not be retaliated against for doing so. Also, employees should understand that if they witness misconduct, even if they're not the victims of it, they still have a responsibility to report it.
All right, let's talk about training. You know, depending on where you are located, you may or may not have to provide training. You know, as always, at the federal level, there is, it differs than state, right? No federal mandate to provide training. And again, it changes by state. And again, we're giving examples of New York and California. In New York, there's no mandate, but in California, you have to train supervisors if you are a company of a certain size. So, but let's put the laws aside and, ask the question, should you train your employees? And of course, if you ask us, we're going to say yes. And even if the law doesn't mandate it, that, we believe that a training program, specifically one that focuses on respectful treatment of everyone in the workplace, that it can actually have an effect. And so related to that, you might be asking yourself, does training really work? If you may remember, it was probably about a year, maybe 2 years ago now, that it was in the news a lot that sexual harassment training doesn't work. And a lot of this was based on an EEO study that they themselves did, and they found that frequently it doesn't. And so what they actually started recommending, now this is the EEOC, the enforcers of the law themselves, they recommend that the training itself should not focus on the law. And it basically comes down to this, telling employees that the company may be sued is going to fall on deaf ears. So instead, you have to focus on a respectful workplace. One of the best practices as well is to really make it personal. And that can include, the example we have here is called the loved one litmus test, which is basically you ask employees that to think about in any workplace situation that they're in that might be questionable, to ask themselves, would they feel comfortable knowing that their sister or their mother were in this situation, or maybe if they have a brother that is gay or a sister that is gay, similarly, right? That thinking about them being in the situation will give them some perspective on, is this really okay?
So what do you do if you get a complaint? You can't hope that this will all go away with a smile or a nod of understanding, and then a promise to take care of it, followed by inaction or insufficient action. If you even think this issue could be larger than a typical complainerson doing what they do best, talk to HR and legal counsel. So 5 things you can do right now. Make sure you have up-to-date policies. Make sure that your procedures are clear and that they're in alignment with the laws, that you have a respectful workplace conduct, and that you provide training. So like it says here, we're not saying that all of these are easy or free, but consider the alternative.
All right, so like we said, that was going to be fast. So that was our lightning round about sexual harassment, what it is, how to recognize it, what to do about it, how to prepare for it. So a quick word on us, on PEAR, your human capital management experts. How the big question is, how can we help you? Obviously, we want to first let you know how we can help you in relation to claims like sexual harassment. We can come in and we can update and we can create policies for you. Your both individual policies like sexual harassment, but also your handbook. And if you find yourself in in a situation where someone has made a claim, give us a call. We can run an impartial investigation. And like we talked about earlier with that case study, that we can interview employees, we can look at documentation, we will give you an impartial view of what's really going on. In addition to that, we provide general HR support to companies. We can help you with one project, or we can become your entire team. We can help you hire 1, 1,000, doesn't matter. Give us a call. We can talk about it. We can help grow your leaders. We can help grow your teams and improve their teamwork together. And we can measure your employees' commitment to your company, and we can help you, hopefully, to increase that. So if you have any questions, here is our information, 212-481-6060. Give us a call again. This is Dave and this is Steph. And we hope that you found this helpful. And don't forget, there are 2 more of these coming up. The next one is going to be urgent HR changes that you need to know now. And after that, we're going to cover performance management and talk about what you can do that actually can produce results. So thanks very much for watching. We really appreciate it.